So this is known as a contingent event. Okay. So goods are of three different types. Either they are existing goods, or they are future goods, or they are contingent goods. Okay. Existing goods are goods present on the day and time the contract is being entered into. Future goods are goods which will arise or which will be there at a later date, while contingent goods are those goods which will be there if an event occurs. If an event occurs, the goods will be there. Otherwise, the goods will not be there. For example, I will sell goods when the ship arrives. So only when the ship arrives, the goods will be there. Otherwise, they are not there. Okay. Then even this existing goods can be further classified into specified goods and unspecified goods. Okay, they are known as either specific goods, and that is ascertained goods, or not specific goods, that is unascertained goods. Okay, now I gave you an example. I said that I am going to sell a mobile phone. Okay, that is what I said. Now I am a dealer who deals in the mobile phones of different categories. Okay, just give me 1 second. Say I have got mobile phone of Apple. I have mobile phones of Samsung. Okay, I have LG mobile phones. I have Honor One mobile phones. Different mobile phones are there with me because I am a dealer in mobile phones. All the mobile phones that are lying with me, they are known as unascertained goods. All the mobile phones lying with me are known as unascertained goods. So say for example, is a buyer comes to me and is asking me for a cell phone. Okay, he is coming and asking me for a cell phone. All the cell phones lying with me in my shop, they are unascertained. Suppose he picks up one phone and says that he wants to buy this phone. The phone that has been identified by the buyer is known as ascertained good. That is known as specific ascertained good. Before he has picked up the phone, all the mobile phones lying in front of him, they are known as unascertained. Okay, they are known as unascertained goods. So we have classified goods into different categories. Okay, specified, ascertained, unascertained, future goods, and contingent goods. Okay, why is the need to identify the goods as specific or ascertained or unascertained? Because in a contract of sale, if the goods are specific and the goods have perished, that is, they have been destroyed, the contract shall become null and void if they are perished without the knowledge of the seller. Okay, but after the subject matter of contract is destroyed, the contract cannot be carried out. Okay, the contract cannot be carried out. But when there is a destruction after the agreement to sell, but not before sale, then an agreement to sell specific goods will become void. If the goods, for no fault of the buyer or the seller, they perish. Okay, so that is the reason why you will have to study whether the goods are specific or not specific goods. Okay, now here there are certain elements, essential elements in a contract for sale of goods. The first essential element is that the sale of goods relates only to movable goods. Okay, a contract for sale of goods relates only to movable goods. It does not relate to immovable goods. Okay, that is the first point that you have to remember, that they are of movable goods. And then in a contract of sale, there are two parties. One party who is buying the good, known as the buyer. Another party known as the seller, who is the person who is selling the goods. There are always two parties, a buyer and a seller. Then for a contract of sale of goods to be valid, there should be something known as consideration. What is consideration? I've told you on a previous occasion, something in return is known as consideration. Consideration is something in return. Without consideration, there cannot be a contract of sale of goods. Then the contract of sale of goods should be a valid contract. What is a valid contract? A valid contract is that contract that satisfies all the essential elements of a valid contract. That is, there should be an offer, there should be an acceptance, there should be a legality of object, the party should be competent to contract, okay, there should be consideration, and the consent of the parties should not be through coercion, undue influence, misrepresentation, fraud, or mistake. When all these elements are present, then the contract will be a valid contract. More so in the case of a contract for the sale of goods also, the contract should be a valid contract. So if any one of the essential elements in a contract of sale of goods is absent, then a contract for sale of goods cannot be a valid contract. Okay. Okay, then next, there should be an agreement to transfer the ownership. What is the meaning of transfer of ownership? Transfer of ownership means when the title of the goods passes from the seller to the buyer. It is known as transfer of ownership. When the title for the goods transfers from the seller to the buyer, it is known as transfer of ownership. What is the meaning of title? Title means the ownership of the goods. Suppose I have purchased a mobile phone. When does the transfer of ownership take place? When does it take place? After the payment of the price. After the payment of the price. Now here you see, suppose I purchase a mobile phone. I have selected a mobile and I said that I want to purchase this mobile. The mobile always will be in a box. Remember, it will be in a box. Only after you pay the price, he will open the box for you. Before you pay the price, he will not open the box. So only when the price is paid, ownership will be transferred from the seller to the buyer in a contract of sale. But there is another contract known as contract for agreement to sell. What is a contract for agreement to sell? There's a difference between sale and agreement to sell. Sale is the ownership will transfer from the seller to the buyer right away, right when the price is paid. But in a contract of agreement to sell, the ownership will transfer from the seller to the buyer upon a future date. Upon a future date. That we will see a bit later difference between sale and agreement to sell. Then the method of formation of contract may be express or implied. A contract of sale, the method of formation may be either express or implied. What is express and what is implied? Express contract is that contract that is entered into by words spoken or written, while implied contract is that contract which is entered into not by words spoken or written, but it is inferred, understood by the acts of the parties, by the action of the parties, by the behavior of the parties. It is understood that a contract of sale is, that a contract is being entered into. Such a contract is known as an implied contract. Okay. Then the last one is transfer of general property. That is, there must be a transfer of general property and not special property in the goods. Okay. Now we will see what is the difference between sale and agreement to sell. This is important from the examination point of view. Sale and agreement to sell. The first point of difference is ownership. Ownership passing from the seller to the buyer. In a contract of sale, ownership will transfer immediately, while in a contract of agreement to sell, ownership will transfer not immediately but at a later date. It does not pass from the seller to the buyer. Okay. Sale is an executed contract, while agreement to sell is a executory contract. What is executed and what is executory? Executed means when both the buyer and the seller, that is, when both the parties to the contract have fulfilled their obligation, then such a contract is called as executed contract. Suppose I purchase a mobile phone. I am the buyer, you are the seller. So what is my obligation? I have to pay the price. What is your obligation? You have to give the delivery. When I have paid the price and you have given me delivery, it is executed contract. The contract is over. While executory contract means where one of the parties has fulfilled his obligation, but the other party has not yet fulfilled his part of the obligation, it is known as executory contract. That is, I as a buyer, I have paid the price. My obligation is over. But you as a seller, you have not yet delivered the goods to me. Then this contract is executory, not executed. Okay. So a contract of sale is executed, while a contract of agreement to sell is executory contract. Then the third one is a contract of sale creates right in rem. Right in rem, R-E-M. While a contract of agreement to sell creates a right in personam. Right in personam. Now this requires some kind of an explanation. What is a right in rem and what is a right in personam? Right in rem means right against a thing. Right against a thing. While right in personam means right against a person. Okay, right against a person is called as right in personam. What is the difference between these two? If the right exists against an object, it is called as right in rem. Suppose, for example, I have purchased a mobile phone. What is the duty of the seller? He has to give the delivery to me. Okay. If it does not give the delivery to me and it is an executed contract, then I can sue the person for delivery of my mobile phone. Right in personam means that I can go to the court of law against the person who has not fulfilled his obligation, but not against the thing that is the subject matter of contract. So this is right in rem and right in persona. And the next point of difference is a contract of sale can take place only in the case of an existing good. Okay, only in the case of an existing good and in the case of a specific good. While a contract of agreement to sell can be of an existing good or it can be of a future or contingent good also. Okay, it can be of a future or contingent good. Then the seller can sue the buyer. Okay, the seller can sue for the price though the goods are in his possession in a contract of sale. While in a contract of agreement to sell, the seller can sue for damages if the buyer refuses to take the delivery of the goods. Okay, then the right of resale. In a contract of sale, the seller cannot resell the goods except under certain cases. The subsequent buyer will not acquire a good title to the goods if he buys them. But in a contract of agreement to sell, the subsequent buyer gets a good title provided he purchases them in good faith and for consideration. And the last point of difference is if the seller resells the goods, the buyer can claim damages for conversion and exercise right of recovery of goods from third parties who are aware of the prior sale. But in a contract of agreement to sell, the case of resale, the buyer can only claim damages. Okay. Then the other points of differences are if the goods are destroyed by accident, the buyer has to bear the loss in the case of sale. But in the case of agreement, if the seller has to bear the loss, even if the goods are in the possession of the buyer. If the buyer becomes insolvent, the seller, in the absence of lien, must deliver the goods to the official receiver and claim damages only. And in the case of agreement to sell, if the buyer becomes bankrupt before payment of price, the seller may refuse to deliver the goods unless paid for rateable dividend. The last one is, if the seller becomes insolvent, the buyer can recover the goods from the official receiver. But in the case of agreement, the buyer who has paid the price can only claim rateable dividend. Okay. Then the next important thing is conditions and warranties. That is 6.9 on page number 88 of your material. Okay. Now here we will see what is a condition and what is a warranty. What are conditions and warranties? Okay. Now, see, understand this very carefully. When a contract of sale is being entered into, the seller will make many statements. He will make many statements in order to induce the buyer to buy the goods. Now, these statements, they are known as representations. They are known as representations. When this representation is false, it is known as misrepresentation. You all know that. When the seller making this representation is not aware that the statement he is making is wrong, then it is called as mistake. But if the seller is aware that the statement he is making is false and yet makes the statement, it is called fraud. I'll give you an example. Suppose I want to buy a pen. When I'm buying a pen, there is a purpose for which I will buy the pen. What is the purpose? That the pen has to write. The pen has to write. If the seller is selling me a pen, saying that this pen writes beautifully, this pen writes beautifully, and I believe that the pen will help me to write beautifully, and I buy the pen. Okay, and I buy the pen. Subsequently, I find out that the pen does not write at all. If the pen does not write at all, it is a breach of condition. If the pen writes, but it doesn't write beautifully, that is, it does not help me improve my handwriting, then it is a breach of warranty. Okay, it is a breach of warranty. I'll give you another example, which I think you will understand even more easily, because all of you use mobile phones. I'll give you an example taking mobile phone only. You buy a mobile phone. What is the main reason why you buy a mobile phone? Because a mobile phone is a device for communication. You buy a mobile phone to talk either to your friends or to your parents or to your colleagues or to somebody to whom you make a call. That is the main intention. First one. Second intention is that you want to take pictures, you want to take photographs, you want to take videos. All this will be your another intention of buying this cell phone, your mobile phone. Suppose you buy a mobile phone and that mobile phone, with that mobile phone, you're not able to make calls at all. You're not able to make calls at all. It is a breach of condition. It is a breach of condition. Suppose your mobile phone does not charge well. It is a slow charging phone. It does not charge at a least time. It is not a fast charging phone. Then you cannot return the phone to the seller saying that this phone doesn't charge well. No, because that is a breach of warranty. But if the phone, you are not able to talk or converse or communicate with the phone at all, you can return the phone because it is a condition. So now I will define a condition. A condition is a promise that is fundamental to a contract. A condition is a promise that is fundamental to a contract, while a warranty is not fundamental to the contract. A condition, when breached, it can nullify the contract, while a warranty, when breached, cannot nullify the contract. A condition, when it is broken, the contract becomes void, while a warranty, if it is broken, the contract becomes voidable. Okay, these are conditions and warranties. Okay, any doubt you have here regarding conditions and warranties? No. So here you see what is the difference between a condition and a warranty. The first difference is difference as to value. Okay, difference as to value. That is, if the mobile phone does not allow me to talk at all, that is, it is non-functional as a piece of communication, the value of the mobile phone will be reduced to zero, will be reduced to nil, because it is fundamental. If the mobile phone has a problem with charging, the value will not be reduced to zero. The value will come down. Okay, because he may replace the charger or he may replace the charging port. He will only replace the charging port if it is not charging properly. But if the phone is, you're not able to talk or converse with the phone, he has to change the phone completely. So look at the value of a condition and value of a warranty. The value of a condition is more, while the value of a warranty is less. That's the first point of difference. Then second is difference as to breach. What is the meaning of breach of contract? Breach means breaking of contract. So where there is a breach of condition, it may give rise to repudiation of the contract. What is repudiation? Repudiation means cancellation of the contract. When a condition is breached, the contract will be cancelled altogether. But when a warranty is breached, the contract cannot be cancelled, but it gives rise to certain damages. Okay. So the breach of condition not only gives a right to treat the contract void, but also gives a right to claim damages. Okay, but also gives a right to claim damages. While a contract of warranty gives rise to claims of damages only. And the difference as to treatment of a condition and a warranty. See, in certain circumstances, the breach of condition can be unilaterally treated as breach of warranty, but a breach of warranty cannot be treated as a breach of condition. Okay, cannot be treated as a breach of condition. Then an important question from the examination point of view. What are the implied conditions in a contract of sale of goods? What are the implied conditions and warranties in a contract of sale of goods? Now here you see, we are telling implied. We are not saying stated. We are not saying expressed. Okay. See, whenever you purchase any good, you purchase it with an intention that it will satisfy the need for which you are purchasing it. It will satisfy the need for which you are purchasing it. So, the first implied condition is that implied condition as to title. Title means ownership. Suppose I am selling one good to you. Okay, I am selling a good to you. Suppose take the case of a second-hand mobile phone. Suppose I am selling you a second-hand mobile phone. The buyer will assume that I, as a seller, have a right of ownership on that phone, that I am the owner of that phone. He will not ask me again, are you the owner? Or did you buy it? Did you steal it from anywhere? Like that, he will not ask you, except when you go to a market like Jumeirah Bazaar, where stolen goods are sold. There you don't go and ask the seller, are you the owner of these goods? Is it legal for But when you buy, say, a washing machine, or when you buy a television from a branded dealer, it is assumed that the dealer has a right to transfer the ownership, because he has got a right to transfer the title on the goods. You will not again go and ask him, because it is implied that he will have a condition as to title. Okay. Then sale of goods by description. Sale of goods by description. Usually what happens is, when you are buying the goods, it may not be possible for you to examine each and every good. Suppose you are buying in bulk. Suppose you are buying in bulk. It may not be possible for you to examine each and every good. Suppose I am buying 1,000 shirts. I am buying 1,000 shirts. And I say to the seller that I want 1,000 cotton shirts. The seller has given me a lot of 1,000 shirts, saying that these are cotton shirts. This is sale by description. I will not examine each and every shirt to see whether it is a cotton shirt or not a cotton shirt. Okay. So this is sale by description. Then sale by sample. Sale by sample. Suppose I want to buy a bag of rice. Okay, I want to buy a 100 kg bag of rice. If I want to buy this bag of rice, I will just take 1 kg from that 100 kgs and I will cook that 1 kg and see whether the rice comes out fine or not. Or I may just pick up a few grains from that sack of rice, from that bag of rice, and put it in my mouth and see whether the rice is suitable for my consumption or not, according to my taste or not. Okay. So here what I have done, I have picked up a sample. I have picked up a sample. Suppose I have taken the sample of 1 kg and then I went home, I cooked that rice and then I found it to be satisfactory. I found it to be good. Then I go to the seller and ask him to give me that bag of 100 kgs. He will give me that bag. The entire 100 kgs should be the same as that 1 kg sample that I have taken. Okay, the entire 100 kg should be same as the 1 kg sample that I have taken. Why? Because this is sale of goods by sample. Look at the difference between the first and the second. The first is sale by description. Okay, where I have described the goods and I have sold them. The goods should answer the description. When I sell the goods by sample, the bulk here meaning the 100 kg, should be similar to that of the sample. Bulk cannot be different. The sample cannot be different. It has to be similar. That is the second implied condition. Then condition as to quality and fitness. Condition as to quality and fitness. See, when I purchase a good for a specific purpose, it should be fit to serve that purpose. It should be fit to serve the purpose. Suppose, for example, I buy a loaf of bread. I buy 1 loaf of bread. Why do you think I will buy the bread? To consume. To consume, I will buy the bread. And I went home, I bought a loaf of bread from a bakery. Then I went home and I took the bread and I put it in my mouth and I started chewing the bread. Suddenly, 1 stone from the bread, it breaks my teeth. One stone from the bread breaks my teeth. Is the bread fit for consumption? No, because it was not able to satisfy my basic need. Suppose I buy a chair. Why do I buy a chair? So that I sit on it. The moment I sit on the chair has collapsed. Is it fit? It is not fit for use. Okay. So when I purchase any product, when I purchase any good, such a good should be fit for use, fit and serve the purpose for which it is being brought, the purpose for which it is being purchased. Usually, I will not buy the good for just for the heck of it. I will buy the good because it satisfies certain need, certain desire, certain want within me. That's the reason why I purchase. Suppose, for example, now here, one case law is there. The case law is the Griffiths versus Peter Conway Limited. Okay, Griffiths versus Peter Conway Limited. Now here in this case, the case is a person purchases a coat from a manufacturer. Now this coat is suitable. Okay, this coat is suitable. Are you listening to me? Are you there?
Yes, sir.
Yes, sir.
Okay, thank you. Suppose I purchase, now here in this particular case, a person has purchased a coat, and after wearing that coat, he has developed rashes over his body. He has developed rashes over his body. Now this person goes to the seller and then he files a case against him saying that because he has used the coat brought from the seller, he has suffered rashes on his body and he wants to file a case against the seller. Now this particular coat was fit for the purpose for which it was being purchased in the market. But this gentleman who purchased this coat had a skin condition, had some problem with his skin. Because he had problem with his skin, that coat caused some allergy to him. That's why he had rashes on his body. But if the same coat was worn by a vast majority, there was no problem at all. There was no problem at all. So here, the goods are fit for general use, but they are not fit for a specific purpose or a specific person. Okay. So when the goods are fit for general consumption, then it has satisfied the condition as to goodness of fit. It has satisfied the condition of fitness to use. If they do not satisfy a specific purpose, then you cannot say that the goods have failed this condition. Okay. And then, see, a good can be used for many different purposes. Generally, it will be used for a specific purpose. Now, suppose, for example, you have purchased a motor car, and this motor car is a passenger car. You have purchased this for your private purposes. That is going to office, coming back home, you have purchased a motor car. Suppose you use the motor car as a taxi and you run it on a daily basis for at least 3-4 kilometers and the car gets spoiled. Okay, the car gets damaged because of this excessive use, and you have not told the seller that you are going to use this as a taxi. Okay, that is, the seller is not aware of the purpose for which the goods are being purchased, then he cannot be made answerable. He cannot be made answerable. But if you tell the seller the specific purpose for which you are buying the goods, and the seller tells you that these goods satisfy that purpose and they do not, then that is a breach of implied condition. But when you have not told the seller the reason why you are buying, and then you use the goods for a reason that is not reasonable enough, then there is no breach of condition. Okay, in a contract of sale. Okay. Now here I will give you, there are certain case laws here. Now the first case is Morrill versus Fitch and Gibbons. Morrill versus Fitch and Gibbons. Now here M, that is Morrill, he asked for a bottle of Stone's ginger wine at a shop belonging to F. Okay. When M was pulling out the cork, when he was pulling out the cork from the bottle broke and it injured M. Here it was held that the sale was by description and M was entitled to recover damages as the bottle was not of merchantable quality. Okay. In another case, Wilson versus Rickett, Cochlear and Company. A purchased cooking coal from B. The coal contained an explosive substance which exploded and caused injury to A. It was held that the coal was not of a merchantable quality as it was not fit for using as a cooking coal. Okay. Then another important thing that you have to understand here is, see, when the goods are sold by the seller to the buyer inspects the goods, sees the goods in total, and then purchases the goods. Subsequently, when he goes home, he finds that there is a small hole, okay, small hole in the goods that he has purchased. Okay, we will take a shirt. Okay, a buyer has purchased a shirt from a seller. He has opened the shirt completely, and then he has seen the shirt right from top to bottom. And after satisfying himself completely that the shirt is perfect, he has purchased the shirt. Subsequently, when he goes home, and then when he looks at the shirt even more carefully, he finds that there is a small hole in the shirt. This hole is known as a defect. Hole is known as a defect. A defect can be a latent defect or a potent defect. Latent defect is a defect that is hidden, while a potent defect is that defect that can be seen by ordinary inspection. So, where there is a defect in the product and you as an ordinary person, just by ordinary looking at it, you can find out that defect, but you have not found it out. The seller also is not obligated to tell you the defect. He just gave the shirt to you. You have examined the shirt. There was a hole, but you could not find out that hole, and then you took it home. Can you return the shirt to the seller? I'm asking you a question. Can you return the shirt to the seller? Now, in this case, if you remember that the buyer had a reasonable opportunity to examine the goods. He has also examined the goods. But in spite of his examination, he could not find out the defect. He cannot hold the seller liable later on. He cannot hold the seller because this contract is a voidable contract. It is not void. But however, if the seller had made an effort to plug that hole, to cover up that hole in a manner that the buyer is not able to find it, then the seller would be made responsible. Then the seller would be made liable. Otherwise, the seller is not liable just by ordinary inspection. If a defect can be found out and the buyer doesn't find out that defect, the courts are not established to repair a bad bargain. The courts are not established to repair bad bargains. If you have made a bad bargain, that is up to you to bear, and the courts will not come to your rescue in this kind of a situation. Okay. So here there is one famous quotation. Caveat emptor. Caveat emptor, which means let the buyer beware. Let the buyer beware. So when you are buying the goods, it is your responsibility to check whether the goods satisfy your need in every respect, whether the goods really belong to the owner, okay, whether the goods are fit for the purpose for which you are purchasing. And by ordinary inspection, if you are able to find out any defect, then still if you enter into a contract, the court will not help you. But if the seller has cleverly deceived you, then he had made a fraud, the courts will come to your rescue. Okay, so this you have to understand. This is an implied condition, and in the same way, you have got implied warranties. One of the important implied warranty conditions and warranties, one of the important implied warranty is that if the goods are of dangerous nature and the buyer is not aware of the dangerous nature of the goods, the seller has to make every effort to bring to the notice of the buyer that the goods are of dangerous nature. He has to make every effort to bring this notice of the buyer. If he does not do it, then the buyer would be made liable. Okay. But ordinarily, there are certain exceptions to the doctrine of caveat emptor. Okay. What is caveat emptor? Just now I told you. Caveat emptor means let the buyer beware. So when you are purchasing the goods, you have to behave like a rational person. You have to behave like a person of ordinary intelligence would do. You should not behave like a fool. Okay. Suppose you go to a market and then you ask for a piece of bread, for a loaf of bread. The buyer has given you a bread. Just by looking at the bread, you will know whether the bread is fresh or not. Just by looking at the bread, you will know whether there is fungus or moss on the bread. Suppose a seller has sold you a bread that has got fungus built up on it. You have purchased that bread even without ordinarily inspecting the bread. Now here, There are two ways of looking at it. Either you can say that there is a breach of implied condition of goodness of fit, because when you purchase a bread, it has to be fit for consumption. You can say the bread was not fit for consumption, therefore you can repudiate the contract. Consequently, the court of law may also give a ruling saying that you had every opportunity to inspect the bread, but you have not inspected it. So you were acting out of your own foolishness. Therefore, you will not get any compensation. That also, it is possible. So therefore, there are certain exceptions to the doctrine of caveat emptor. First one is custom or usage of trade. Okay. Now here, usually when goods are purchased, they're purchased for a specific purpose, as I told you. Now, why do you purchase, say, why do you purchase an electric kettle? Why do you purchase an electric kettle? Can anybody tell me why you purchase electric kettle? You know what is a kettle? Don't tell me you don't know what is a kettle. See, suppose for example, assume you purchase a geyser, a water heater or a geyser. What is the purpose for which you are buying? That it will provide hot water whenever you switch it on. Okay. So that is the implied condition in that good, that it will be used for boiling water. Okay. When you purchase a kettle, it is implied that you will use it for boiling water. You need not tell the seller again that you are buying this kettle to boil hot water. It is understood. Okay. So here, when you are buying this kettle, the doctrine of caveat emptor will not apply because of the implied condition as to goodness of fit. Okay. These two run contrary to each other. One doctrine of caveat emptor says you have to be careful. The doctrine of caveat emptor says that the buyer has to be careful when he is buying the goods. Then an implied condition or warranty says that the good has to satisfy the fundamental reason for which you are buying it. All said and done, an agreement or a contract where the usual practice is to use the goods in a certain way, and if the goods are unable to be used in that way, then there is an implied breach of condition, and the doctrine of caveat emptor will not apply. Then second is when there is a fraud. I told you an example. When the seller cleverly conceals the defect so that you are unable to find out. Subsequently, when you find it out, then the doctrine of caveat emptor will not apply. Okay, he will not tell you, the courts will not tell you that you should have examined carefully, because the seller by deceit has covered up the defect in such a way that you by order inspection you could not have found it out. That is why the doctrine of caveat emptor will not apply in the case of a fraud. Then in the case of specific purpose, so when you purchase goods for a specific purpose and you ask the seller whether the goods satisfy that purpose, and the seller says that yes, they satisfy, subsequently they do not satisfy, then the rule of caveat emptor will not apply because you have relied upon the words of the seller. So whenever you rely upon the words of the seller, the doctrine of caveat emptor will not apply when the seller has defrauded you, when there is a fraud. Then the goods should be of merchantable quality. That is, the goods should be such that they should be of merchantable quality. What is merchantable quality? That they should be capable of being bought and sold in the market. Okay, they should not be such that they perish while on the way. They should not be such that they perish while they are being sold in the market. They have to be able to take the journey that you will undertake to sell the goods in the market. And then the last one is that, as I told you, dangerous nature of the goods has to be declared. And when the goods are not of merchantable quality, okay, the goods also have to be declared that they are of merchantable quality. Okay, this is with regard to the implied conditions and warranties in a contract of sale. Okay, so with that we have completed unit 6. Any doubts here? Okay, so I'm going to end the class, leave the class for now. Tomorrow again we will carry on with the class where we will see transfer of ownership. Okay, so I'm leaving the meeting now. Thank you very much for your patient listening. See you all tomorrow. Thank you.